You're listening to the Max Planck Lawcast, which showcases the academic research currently being conducted across the Max Planck Law Network. I'm your host, Christopher Murphy, and together we'll be talking to some of the more than 400 researchers who are pushing the frontiers of legal knowledge in Germany and abroad. When it comes to new and exciting legal research, the Lawcast has you covered. Well, welcome back to another episode of the Max Planck Lawcast. On today's episode, we're going to be exploring how liberal democratic norms are being contested, and we're going to do this by taking abortion rights in the United States as an example. As diligent Lawcast listeners will know, in 2022, the US Supreme Court declared that the constitutional right to abortion no longer exists. As diligent Lawcast listeners will also know, this far-reaching decision has resulted in fierce protest and division. Now, using this aforementioned example, today's episode will unpack the concept of norm decoupling, a term that describes how certain liberal democratic norms are being isolated from their traditional connections, thereby leading to divergent interpretation and application. Moreover, we'll assess whether the handling of abortion rights in the United States is indicative of a more general backsliding of liberal democratic norms. To do so, I'm pleased to be joined today by Janne Mende. Janne is a political scientist and senior research group leader at the Planck Institute for Comparative Public Law and International Law in Heidelberg. Her research focuses on global governance, international organizations, human rights, and, most importantly for today, norms. Janne, thanks very much for coming onto the Lawcast.
Thank you. It is great to be here.
I should note before we begin proper that Janne has published a detailed paper on today's topic that will certainly go deeper than what we can do. So if you'd like to read up more on what we're talking about today, I'm going to leave the link to this paper in the podcast description. So, over to you now, Janne. Liberal democratic norms. They sound great. I mean, they're liberal, they're democratic. These are two aspiring political goals. But before we even talk about the liberal democratic norms, I'd like to ask what exactly a norm is. I used to live next to a neighbour in Australia whose name was Norm, but I gather your research is not about my neighbour down under.
My research is not about your neighbour, indeed. There are different definitions of norms in social and legal sciences. Nevertheless, we can identify a common approach to norms. And this defines norms as standards that guide what is perceived as appropriate or as desired behavior for actors in a given shared context. And norms may actually come in the form of laws, but not all laws are norms. So you can think of laws that are forgotten or that do not play a role for our lives. And also vice versa, not all norms are laws. Norms can also come in many other forms, such as in the form of institutions, of practices, or of rituals. One more thing when we talk about norms, which is interesting to note, norm robustness or the strength of a norm does not necessarily depend on that actors comply to the norm, but also it is important how actors react to the breach of a norm. So whether a norm breach is sanctioned in a given context. And if the condemnation of a norm breach is high, then we can talk about a strong norm.
So a norm in that sense is an extra special rule, if you will.
If you will, it can be a rule, but it can also be something more implicit.
Mm-hmm.
But it is always connected to expectations of what counts as desirable or as appropriate.
Desirable or appropriate behavior, if you will.
Mm-hmm.
Okay, right. Good. Well, we've established we're not talking about my neighbour, Norm, in Australia, so that's good to know, although I'm sure he'd love to be on the show. Let's say, okay, we know now what norms are. What then is a liberal democratic norm, and what are some examples that our listeners might know from their daily lives?
So as a social scientist, I feel obliged to begin by saying that, again, we have different approaches. For example, there are different kinds of liberalism which may focus on the economic aspect of liberalism or the political aspect of liberalism. But having said that, we can identify norms that are usually referred to as liberal democratic norms. And these include, first and foremost, the rule of law, or what more recently also is referred to as the rule-based order. Also, all the norms relating to human rights are seen to be at the core of liberal democratic norms. Then another important aspect is multilateral and international cooperation between states. and with that, the sovereign equality of states. Another shared norm is that of peace, and this includes the peaceful settlement of conflicts, and finally, the equality of human beings, which also includes gender equality.
Okay, right. So there's a number of norms there. I mean, rule of law, I think everyone knows, or as you say, the rule-based order, sovereign equality of states certainly should exist and does, thankfully, for the most part, as does international cooperation. You touched at the end there on equality of human beings and also gender equality. Is gender equality then the norm that's at the heart of the debate on abortion rights in the United States, or are there other norms at play as well?
Well, gender equality indeed seems to be the norm that is most affected by abortion laws at first sight. And actually, gender equality is connected to a variety of further norms. These include sexual and reproductive rights and also the right to non-discrimination. In addition to that, the right to abortion also affects many other norms. Most visibly, this is the right to individual self-determination, the freedom of choice, bodily integrity, the right to privacy, dignity, and liberty. Furthermore, there are also norms affected by abortion rights, and these also are norms that usually mark a liberal democracy, or at least its normative aspiration. And these norms include the access to education, the access to proper healthcare. So what I'm saying is that if you deny women access to abortion, this may generate years-long economic hardship and insecurity. It includes a heightened risk of poverty, lack of economic and social participation, and it can mean for a woman to stay in a violent relationship. All of this affects both the mother and the children, by the way.
Mm-hmm.
Recent examples in the US and beyond also show that women die even when there is proper health care, because medics are or may be afraid to save a woman's life because of the prohibition of abortion. This happens actually on an everyday basis since many years in countries with restrictive abortion laws, not only in the US, also, for example, in Malta. And finally, I don't want to forget all those women who die from abortion attempts that are not conducted by professionals. Only few of these cases make it to the media.
Okay, right. So I can see, as you say, there's a great deal of norms at play here, not simply the gender equality norm, but as you say, there's a lot of norms that knock on from that. You know, we live here in Germany where the right to abortion does exist.
Well,
or does it not?
It is more complicated in Germany because actually it is not legal to have an abortion, but if you have an abortion under certain circumstances, then you will not be prosecuted.
Oh, look at this. I'm learning all kinds of new stuff on the Lawcast. Well, okay. I did not know that at all. I figured that was the case. So I see. So before we go to Germany again, though, let's stay on our US. That was an idea there with abortion rights in the US, though. This is something that certainly has been talked about a lot of late. I think, as mentioned at the start, 2022, the case there in the Supreme Court. Would you mind giving us, I guess, a rundown of the history of abortion rights in the US, and then kind of ending with the current decision of the Supreme Court and the status quo as is? I know, actually, we're just recording this after the US election. Abortion rights seem to be on a lot of the ballot papers of the states as well. So if you could give us a succinct summary of the rights in the US, that would be lovely.
Yes, of course. So you can tell the history of abortion rights in the US very well because it developed along three landmark cases of the US Supreme Court. The first case is called Roe v. Wade, or shortly, simply Roe. This is a decision that was taken in 1973, and it was revolutionary because for the first time it framed the right to abortion as a right that is constitutionally protected. And with that, it made the right to abortion mandatory at the federal level. This means that no US federal state could legally prohibit abortion anymore.
Okay, because that's definitely the one I hear about a lot, Roe v. Wade. So that was obviously as you say, the first and the most seminal case.
Exactly, it was. It is accompanied by a second case from 1992, which is called Planned Parenthood of Southeastern PA v. Casey, or simply short Casey. So the Casey judgment was dedicated to details of the regulation and the timing of abortion laws. In principle, it reaffirmed Roe in its essential holdings, Particularly, it reaffirmed to consider the right to abortion as a matter of constitutional protection. But it did shift some details. For example, Casey allowed state regulation of abortion in the first trimester of pregnancy. And it also introduced the undue burden standard. This restricts the regulation of abortion if it puts an undue burden on the woman.
Okay, right, so I understand. So this kind of reinforced, though, in many ways, the decision of Roe v. Wade in Casey. Then there's obviously a third decision, the most recent one.
Exactly. This is the infamous decision from 2022, Dobbs v. Jackson Women's Health Organization, or short Dobbs. So Dobbs again was revolutionary, however, unfortunately in the opposite direction, because it annulled both Roe and Casey. And this is actually something the Supreme Court does not do very often and for which it needs very good reasoning. With the Dobbs decision, the Supreme Court explicitly withdrew the constitutional protection of the right to abortion at the federal level. So just to be clear, this does not mean that the Supreme Court prohibits abortion, but it means that it enables federal states to prohibit abortion with no further strings attached. And this means that states may, and partly did, introduce abortion laws of the most restrictive kind, even from the moment of conception on, and even in cases of rape and incest.
Mm-hmm. And that's when I was talking about what was on the election ballots now. These were some of the decisions on how the individual states then would regulate abortion.
Exactly. And some states then tried to introduce some measures in their own federal state constitution in order to protect the right to abortion from its prohibition.
Mm-hmm. Okay, and so this has kind of led then to this patchwork across the United States, some states having a liberal approach, some having a restrictive approach.
Exactly, but the restrictive approach may also mean to prohibit women traveling to other states to get an abortion.
Ah, okay. What gets me, though, that's obviously there's this patchwork issue, so we'll put that aside. I think that's because it's a whole other issue here we need to talk about. We can't talk about today, unfortunately, because we don't have time. But what I wanted to look was more at the federal level. You did say that Dobbs was highly unusual in that the Supreme Court kind of really changed fundamentally previous rulings. What I don't kind of get, it was considered as a fundamental liberty. In two cases over decades, there was this fundamental liberty, constitutional right to abortion. The court then said, no, this no longer exists. So this is just basically constitutional interpretation of the sitting court at the time then, or is there more to it?
Well, the short answer is yes, it is all about constitutional interpretation. This is because the Supreme Court does not take on just any case, but it takes on cases that concern constitutional rights and cases that require deliberation of how constitutional rights should be interpreted. And this is what the Supreme Court's job is all about, the deliberation and interpretation of constitutional rights. And this is also what norms, and even more so legal norms, depend on in order to survive and to thrive. Deliberation, contestation, and interpretation. Why is that so? A norm is not necessarily dead if no one acts upon it, as I mentioned before. But a norm is dead if no one acts upon it and nobody talks about this.
Okay, so that would be then the norms in question, though we wouldn't say they were dead, right? They were being debated and talked about, but there was a status quo for a long time.
Exactly.
Okay. So we're kind of back now to norms. We're going to thank you very much for that nice summary of 50, 60 years of legislation and US Supreme Court decisions. But you've come back to norms there. So what role then do liberal democratic norms play for the US Supreme Court?
A short answer is that liberal democratic norms are the very raison d'etre of the Supreme Court, because the court is bound by liberal democratic rules, and it is supposed to apply the US Constitution, to interpret the US Constitution, and this counts as a founding document of liberal democracy. This means, and this is really important here, that the court cannot randomly invoke just any norms or any norm interpretations. It cannot invoke explicitly anti-liberal democratic norms, but it must comply with the Constitution and it must follow liberal democratic rules.
Okay, obviously the Supreme Court's not acting alone here. There are parties involved here who are taking these cases to the Supreme Court. You mentioned the names there, and they're called Roe, Casey, Dobbs. There are impacted parties. What arguments along these liberal democratic norm guidelines do the pro-choice and anti-abortion advocates invoke? And are they kind of invoking the same norms and reading them differently? Or are they invoking different norms that need to be contested against one another?
In order to answer that question, let me zoom in a little bit and just consider the pro and anti-abortion side when it comes to the judges of the Supreme Court, because this is what makes the Dobbs case and the abortion decision so interesting. Let me explain that. Generally, the Supreme Court judges explain their positions in so-called opinions of the court, which is the judgment, their decision.
Mm-hmm.
In addition to that, judges can file further opinions that are concurring with or dissenting from the judgment. And some opinions are also both. They are concurring and dissenting in different points. So what is interesting now is all the opinions voiced in the 3 landmark cases on abortion, all but one single document, all opinions take a very clear stance. They are either clearly for or clearly against a right to abortion. So what we have here is a very dichotomous constellation. However, and this is where it gets interesting when we look at the judges' opinions, the two opposing sides invoke the very same norms. Let me give you some examples. The most dominant norms that both sides, pro and contra abortion judges, refer to are first, the Supreme Court's independence and its neutrality. This means the court shall not be guided by the judge's own political preferences or by the country's political climate or by parties or otherwise by public processes or public opinion.
Mm-hmm. Okay. Also the rule of law, I guess, back to that one foundational norm of a democratic society, that the justice is separate from politics.
Mm-hmm. That's right. And the second shared norm is the respect. It is interesting because it is really explicitly invoked by both sides in a very decisive way. So the second norm they share is the respect for individual moral values. What do they mean by that? This means the court claims that it does not want to simply impose its own opinion, but it wants to respect the different moral values that individuals attach to the topic of abortion. As we know, and so does the court, many people do have very strong values on that topic. And the third joint norm invoked by both sides is that of liberty. And this is also the very purpose of the US Constitution, to protect people's liberty and freedom.
Mm-hmm. Okay, so there's definitely a lot of liberal democratic norms there kind of being pushed up against one another.
Exactly. So, and this is what makes this case so interesting. All of these are undoubtedly liberal democratic norms. And that both sides refer to them does not necessarily mean that one side is decepting the other. Actually, both sides may truly believe in these norms. However, and this is the important point, the ways these norms are interpreted undermine or may undermine their very liberal democratic meaning. And this is because some of these norms are isolated from other liberal democratic norms. This is what I call norm decoupling.
Okay. Well, we'll take a short break, Janne, and then I'll come back to you, and then we're going to be talking more then about norms and, as you just said there, the concept of norm decoupling.
Welcome to Max Planck Law, one of the world's largest networks for legal research, based in Germany. Our world-class institutes invite applications for fully funded PhD and postdoc opportunities in almost any area of law. Join a thriving community of over 400 researchers in an international and interdisciplinary environment. Experience the high quality of life that Germany offers while collaborating with colleagues across institutes, working and writing in English. We provide you with unique specialist libraries, excellent workspaces, and support in developing your research and your academic career. Apply today. For more information, visit law.mpg.de.
Well, welcome back to the Lawcast. Today I'm talking with Janne Mende about the battle for abortion rights in the United States, and in particular the effect that this is having on liberal democratic norms. Janne, before the break you mentioned the concept of norm decoupling. Could you please explain this term and tell us how it kind of manifests itself in the debates then surrounding abortion rights in the United States?
Yes, norm decoupling, when I use the term norm decoupling, I'm referring to the isolation of hitherto related norms. This means that liberal democratic norms do not work alone, but they are interrelated with a number of other norms. Now, if you interrupt these relations, if you isolate certain norms, then this may undermine their very meaning. Let me explain this by showing you how the two court sides in the Dobbs judgment, the contra and the pro the right to abortion side, how they understand the jointly shared norms that I've mentioned before in opposing ways.
Okay, so the norms you mentioned previously before the break, you'll kind of break them down now into the two opposing opinions.
Exactly, and the two opposing interpretations. So the first norm that I mentioned is the court's neutrality, right? But there are very interesting ways of how to interpret neutrality. So the contra side says, when they banned the right to abortion, when they annulled it, they said that this is actually neutral because they are not taking a decision on abortion on the federal level. So remember, they do not allow, but also they do not prohibit abortion. So this is what they frame as neutral.
Okay, they say it's simply then up to the states.
Exactly. And more specifically, they do not only say it's up to the state, they say it's a matter of democratic decision-making, namely by voting. They say if people want abortion rights, then they simply can vote for the political party or the Congress members that will promise them abortion rights.
That means that access to abortion could change in accordance with the prevailing political winds.
Exactly, yeah. And I also want to give you one quote, which I found really telling for this, from one concurring opinion on the Dobbs decision. Here it says, quote, "The Constitution does not take sides on the issue of abortion," unquote. So yes, fair enough, it doesn't. The Constitution does not mention abortion. However, there's more to the question of neutrality and to the question of the interpretation of the Constitution. And this is what the pro side is bringing in. So the pro side says banning the right to abortion, well, actually, that is taking sides. Why? Because true neutrality would mean to protect the constitutional rights for everyone, foremost the rights to choice and liberty for everyone. But the pro side says banning the right to abortion enables federal states to restrict these rights for many women. This is the point they're making.
Okay.
So, and we find very similar interpretations when we look at the second shared norm, namely the norm of respecting moral values of individuals. So here the contra side again says, well, individuals, they can just express their individual preferences via democratic decision-making. They're referring to democratic mechanisms, rather than the judges imposing their own opinion about abortion on everyone. This is the point they're making.
And that kind of feeds back then into the previous argument as well. We're not banning it, but you have to vote for it.
Exactly. But the pro side is making a really interesting point here. They're saying that respecting moral values also means to protect everyone against others' moral values. And this includes protection against the moral values of the majority. And this means the protection of minorities against the majority. And this, again, is a very core democratic norm.
Good point. Interesting point. I hadn't thought of that when we're talking about moral values, but absolutely. It's always good to hear the second argument as well, because there's obviously more than one way to interpret these.
It is, and the pro side really comes up with interesting arguments. I was thinking that as well when reading the documents. So let me shortly come to the third shared norm, that of liberty. The contra side invokes a procedural rather than a substantial interpretation of liberty. That means the contra side focuses on correct procedures, but not so much on what liberty actually is all about, what liberty consists of. This is what the pro side does in contrast. So the pro side develops a substantive reading of liberty, and they are doing this by interconnecting liberty to other norms. This means the pro side defines and interconnects liberty with norms such as equality, privacy, bodily integrity, dignity, and the freedom of choice. These are all norms explicitly invoked by the pro side to define liberty. But the pro side also makes another interesting point. It says that the Supreme Court's interpretation of the Constitution must aim at a balanced regulation of diverging interests. And of course, a society does have and must deal with diverging interests. So they're saying there must be a balance of these interests in order to make sure that indeed everyone's liberty is protected and not just the liberty of, for example, majorities again. And one more point the pro side is doing here, it does something in addition. The pro side attaches norms such as liberty and also the related norms to the lives of women. That means the pro side talks about how the liberty of women is affected differently by abortion laws than the liberty of men.
Okay, right. So I see, obviously, again, it's a whole lot of interpretation going on here. And you say that the contra side in liberty took simply a substantial kind of interpretation, said if the procedures are correct, then the norm of liberty is not in danger, whereas the pro side has taken an absolute different approach and brought in a whole lot of other norms that says need to be also taken into account when discussing liberty.
Yes.
Obviously, it's down to interpretation then, but how are these norms then being decoupled from one another? The norms you mentioned, what did we have there? We had liberty, respect of moral values, and the court's neutrality. These are the norms you're talking about that are being decoupled from one another?
Well, parts of what these norms are based on. So the diverging norm interpretations in these three examples show us two mechanisms of norm decoupling. And this norm decoupling is undertaken by the contra side. The first mechanism refers to democracy, the second to gender. So what do I mean? Regarding democratic norms, the contra side time and again, as I have mentioned, invokes one and only one single democratic norm, namely that of majority votes. So what it does is it isolates this norm from other democratic norms that are just as important. And this is most importantly and most obviously the protection of minorities against majorities. Regarding the second mechanism, regarding gender, the contra side says, and you need to savor that slowly, the contra side says that the right to abortion is not a gendered matter, meaning that this is not a matter that concerns women differently than men. I don't know about you, but I do see differences in how the right to abortion affects women and men. And this is also what the pro side says. The pro side shows how all the norms, such as equality, liberty, etc., how all of these norms are having gendered dimensions. And I would like to give you a quote from the pro side. This is a quote from a dissenting opinion from the Dobbs judgment. And it says, quote, "Of course, people," and they are putting people here in quotation marks, "people did not ratify the 14th Amendment. Men did. So it is perhaps not so surprising that the ratifiers were not perfectly attuned to the importance of reproductive rights for women's liberty or for their capacity to participate as equal members of our nation." End of quote. So what the pro side does here is to show that neutrality too is not really neutral. Instead, what often counts as neutral actually is androcentric. And this means that it has been developed or interpreted only with the needs and experience of men in mind, not that of women, which for a long time remained invisible.
Okay. So obviously what you're saying there is that it was men who were involved in the ratification of, the 14th Amendment and in the drafting of the Constitution as a whole. One term, though, you said they're androcentric. Can you define that for me, please?
Yeah, androcentrism. So andro refers to men, and it only says that even if not intended, the law or constitution or certain norms or certain rules are tailored to the needs and to the experiences of men. And not necessarily in an intended way, but just because the needs and experience of women remained invisible.
Okay, understood. Okay. Right. So there we now see how norms are or can be decoupled. And in this case, it was the contra side of the abortion debate in America who has conducted this decoupling. For my last question, but it's a long question, I'd like to ask then about this decoupling and whether liberal democratic norms, is this just in the context of reproductive rights in general, this decoupling? Or are there, broader implications for liberal democratic societies that this might be a foreshadowing of?
It definitely is. And I want to start by making a more general point on how norms may be challenged. Because there's a more obvious way of challenging norms, and this is to invoke counter-norms. So, for example, if the norm is gender equality, then the counter-norm would be gender inequality. And this often comes in the form of ideas of what is called a natural family, which is the assumption that the heterosexual family with women responsible for child raising and household is something given by nature. Of course, it is not. It has developed as a result of social and political processes, and it is actually historically rather new. So in a nutshell, these are counter norms, explicitly challenging norms such as gender equality. In contrast to that, norm decoupling operates in a less visible way. So at no point did the contra side in the Dobbs judgment invoke anti-feminist ideas or notions of a natural family with its image of housewives, right? What the contra side did was to isolate norms from each other and from their gendered effects. And the more invisible way of how this is working is also a reason why norm decoupling is such a serious challenge to liberal democratic norms more generally. Take the isolation of the majority votes norm from norms such as the protection of minorities or from the protection of fundamental rights. Don't get me wrong here, majority votes do represent a core democratic norm. However, it's isolation from these other norms which may turn it into a repressive tool. And you see that when populists use that tool of majority votes, when they claim to represent the majority in order to exclude and marginalize minorities.
Okay.
Or take the isolation of gendered effects of norms. The US Constitution protects liberty and equality for all, right?
Yes.
But initially, it did not include everyone, and certainly not Afro-Americans who were enslaved. Still, the Constitution and its norms were regarded as neutral back then, because this was a context in which only white men were regarded as full members of society, which were to be taken seriously then. And today, we have persistent gender equalities in many societies. These inequalities are inscribed into many norms as well, including into liberal democratic ones. This means these norms affect men and women or people beyond that binary distinction differently, even if these norms equally apply to all. So if abortion is prohibited for all human beings equally, then women's liberty will suffer differently from that prohibition than men do. Or to give you another example, if sleeping under a bridge is equally prohibited for all human beings, not all human beings will suffer from that, but only those who are homeless. This is important for the very meaning of liberal democratic norms. Taking these gendered effects into account does not weaken these norms. So I do not mean to challenge these norms with this criticism, but it strengthens them, because these norms can only be accomplished for all when you pay attention to their gendered effects and, of course, then their gendered obstacles. So 2 more sentences. Coming back to the abortion decision, it is not even necessary for the contra side to employ decisively anti-feminist or anti-liberal or non-democratic norms. It is not taking the gendered norm dimensions into account that has a similar effect. So against this background, this case shows us how liberal democratic norms are undermined in a less obvious but very steady and very dangerous way. And this is also why this case tells us more about the different ways in which liberal democratic societies are challenged and contested more generally, and how much, I would say, they are at stake now even more than ever before.
Okay, so norms are definitely, even when not talked about, they do continue to play an important role, and perhaps are going to, their contestation and the like will play an even bigger role in the future. Maybe many things that we've taken for granted may no longer be exactly as we now think about them. Is that correct?
That is correct, but maybe we can also end on a more positive note, because it is not necessarily bad for norms if we talk about them. If they are contested and we talk about them, this may also contribute to strengthening the norm in the end.
Understood. Okay. Well, Janne, I want to say thank you so much for providing, I found, very succinct answers to often very complex questions. As noted at the outset, anyone who'd like to know more about norms, liberal democratic norms, the decoupling of norms, not about my neighbour norm, but about any other norm, you can definitely follow the link in the podcast description to find Janne's article. Janne, thanks so much for taking the time to be on the Lawcast with us today.
Thank you so much for having me.
Thanks for listening to the Lawcast. If you'd like more information about Max Planck Law, or if you'd like to get involved, please visit us at law.mpg.de.
Max Planck Law. Excellence in legal research.